Hi guys, hope you are doing well. Today we are gonna start sections of Companies Act. Mm, we are not gonna cover all the sections. We are only gonna see those sections which are important for exam point of view and those sections which are useful to understand the Companies Act. So let's start with section 3A. What does this section say? It's members severally liable in certain cases. Members severally liable in certain cases. In which cases the members of the companies are liable for any punishment? Why do you think they give the punishment? We'll see. What are the minimum number of member in public company? It's 7. In private company, 2. Suppose you started the company and you carried on your business. Company carried business for 6 months or more than 6 months with less than 7 in case of public, 2 in case of private members. They carried on the business without having these minimum numbers. Then what happens if they carry on the business with these minimum numbers? They are severally liable. These numbers are reduced. 7 is reduced, 2 is reduced, and they carried on the business for more than 6 months or 6 months. Then every member after 6 months, whoever is there in the company and whoever knows the fact, they shall be severally liable for whole debt of company contracted during the time. What does this mean actually? At the time of registration, suppose it's a public company, at the time of registration there were 7 members. This is the minimum, so they gathered 7 members and they did the registration. After 1 month of incorporation, 2 members left. 2 members left the company. So total number remaining were 5 members. Total were 5 members. What they did? They continued the business. They did not appointed more remaining 2 members and they carried on their business for more than 6 months. Here comes the penalty. You are not allowed to do so. So these 5 members are liable. That's it. This is only section 3A. We'll go with section 7. It's incorporation of company. Incorporation of company. Section 7 says about incorporation of company. This is subsection 1. Subsection 1 says about documents and information. These documents, the documents of the company and whatever the information of the company shall be filed with registrar whose jurisdictional ROC is proposed to be situated. Wherever your company is situated, there you will be having a ROC. There you should go and register, file your documents and information to the ROC. The first step is that. Next, what comes? You should have to prepare your memorandum, articles of association. This shall be signed by all subscribers of memorandum. What do you mean by this? Subscribers of memorandum, who are the shareholders, who all have subscribed to your shares, who are the promoters, everyone. They should sign the memorandum and articles of the company. You should also provide the declaration from advocate, CA, CMA, CS. This should be in practice. You cannot take any person of employee who are engaged in formation of company. Only these persons who are engaged in formation of company, then you should take the declaration from them. Not any third party who is not involved in this process. You cannot take declaration from those persons. And also person named in article, who director, manager, secretary. You should take the declaration from all these members. Not only this, from all these members. Why do you think declaration is necessary? Declaration is necessary that we will tell them that all the requirement of the act and rule for the registration is complied. We are following all the rules and all the registration regulations, and then only we are going to open this company. We are going to register under Companies Act. All those declarations shall be given by professionals, not by any person who is setting up the company, who is establishing the company. So next, you will take the declaration from each subscriber. Declaration shall be taken from CA, advocate, CA, CMA, CS, who are engaged in the formation of the in the process of formation of the company, and also from the persons who are named in the articles like director, manager, secretary. And declaration shall be taken from each subscriber to memorandum plus the first director. Each person who has subscribed to the memorandum and the first director. Why do you want the declaration from this person and the first director? That we will make sure that these persons are not convicted of any offense. They are not in any offense. They are free. They have not been any case law, any court. There is no case on them. We'll take the declaration from subscriber to memorandums plus the first director. Why do we take that? That not convicted of any offense. Not convicted of any offense. When? When do you think they are convicted, or when there is case going on? They are not convicted of any offense during promotion, formation and management of company. During this period, they are not convicted of any offense, or they are not being found guilty. They are not been found guilty. Guilty of what? Guilty of fraud, misfeasance, or any breach of duty of company. This you should see for preceding 5 years. If they had done any fraud, misfeasance, or breach of duty, anything happens preceding 5 years, then they are found to be guilty and they are not eligible to be the shareholders or to be the members or to be the directors. This comes under the disqualifications for them. And next thing, the document should be filed with the registrar. File these documents, all these declarations you should file with the registrar. What you will file, what you will say to the registrar about regarding these documents, that the information given is complete and whatever information given is true to the best of the knowledge, to best of knowledge and belief. Before taking any person as your shareholder, you will of course verify their details. So before you at the time of verifying, you should verify complete details of such person, and you should be sure, you should collect the accurate data regarding that person. Whatever information you are providing to the registrar, it should be complete and it should be true. You cannot provide any fake certificates, you cannot go with anything which you are unsure about. You should be sure and you should think twice before submitting it to the registrar. And next, what thing you will give? Address for correspondence. Till registered office is established. Until your registered office is established, you should maintain an address for communication. In that in that document, what you will mention, the new address, wherever you would like the registrar to communicate with, you provide those address. And where you would like to set up your registered office, the details are also to be given in this itself. Next one, particulars of persons. What does this include? The name plus surname. You should provide the full name, not the half or anything, or the family name. The residential address of the person, nationality, whether Indian, foreigner, any such other particulars, whatever required, whatever you found out regarding that person, that all you will provide. Another particulars and proof of identity. These all things you will provide. Persons means what? Here person means every subscriber to memorandum. Next, particular of person. Here you'll go with first director who is named in articles. The same details you will provide here itself, and you will here add DIN number of such person, because he is the director, he will be having a DIN number. You should provide the same to the registrar. Next, particulars of interest. Whether he is interested in other firms or any body, corporate, whose interest you should provide. the first director's interest, whether he is a director in any firm, or he is already having directorship in any body corporate, whatever it may be. If he is having already, then he should have to give the declaration, and he should also give the first director should also give the consent that he should also give the consent that he is ready to act as a director to this company. He is not forced to be the director of this company. Him by himself want to be the director of the company. This is the consent that he should give. Also the declaration, also the interest, also his personal identity proofs. Everything shall be filed with the registrar. So once you file all your documents and information with the registrar, second thing will be issue of certificate of incorporation, COI. You should know it. Certificate of incorporation. Who will give you this certificate? Registrar will give you this certificate. If all the documents that you have filed are fair, are good, then they will give you this document, certificate of incorporation. Next, after you get the certificate of incorporation, allotment of CIN. What do you mean by CIN? Just like DIN is the identification number for directors, SIN is the identification number for the corporate, nothing but the company. They will allot you this number. Once you get this number is used in everywhere you'll use this number. Along with the name of the company, you'll use this number. Next, maintenance of all copies of documents and information. Once they issue this SIN number, the registrar of companies, ROC, they should maintain the copies of the documents and the information that we have submitted to it till company is dissolved. Till the company is dissolved, registrar of companies is gonna maintain our copies and our documents and information with it, and at the same time we should also have to maintain it at our registered office until the company is dissolved. Next, fifth one, suppose any person who is aware that you have given false, incorrect, or suppressed material information, suppressed or incorrect information to whom? You have given all these information and documents to the registrar of ROC, didn't you? When you have provided false, incorrect, or suppressed information to the ROC in relation to the registration, at the time of registration you have provided some documents and information. If those are proved to be false, incorrect, then the person who is aware of these things is liable under section 447. It's a penalty for fraud. The amount involved under this section is I'll explain you with a chart so that you can remember. Suppose the amount of fraud is at least rupees 10 lakhs, or if it is 1% of turnover of the company. Suppose if it is at least 10 lakhs or 1% of the turnover of the company, then you will have minimum imprisonment for 6 months. It can go for 3 years if public interest is involved, and maximum imprisonment can go for 10 years. And it is not a or provision, it is and. It means along with the imprisonment, you should have to pay the fine of amount. It is fine of amount involved, 3 times of amount involved in fraud. 3 times. Along with this imprisonment, you should also pay the amount involved in the fraud. 3 times you should pay if it is at least 10 lakhs or more than 10 lakhs. Next, if the amount of fraud is less than 10 lakhs or 1% of turnover, and here also we go with and, no public interest is involved, then you will go with an imprisonment for a term which may extend to 5 years, or here you will go with an or provision. Remember this properly. Here you will go with or provision. Fine extend to rupees 50 lakhs, or if it is more, then you can go with both. Like, understand the difference, guys. If the amount is more than 10 lakhs or more than 1% of turnover, you will go with minimum imprisonment of 6 months, 3 years if the public interest is involved. 3 years. If the public interest is involved, this minimum will be 3 years. If the public interest is not involved, then minimum will be 6 months. Maximum imprisonment can be for 10 years, and along with this imprisonment, you are also liable for a fine of 3 times of the amount involved in the fraud. Suppose if the amount of fraud involved is less than 10 lakhs or less than 1% of the turnover, and no public interest is involved, then imprisonment can extend for a term of 5 years, or you should take the imprisonment, or you can pay the fine up to 50 lakhs, or both can be applied to a single person. In this case, both can be applied, but if you want the both, there should be severe things to be happen, guys. Next, suppose after incorporation, it is proved that you have provided false and incorrect information, or any false material information, or any document that is declared that is false, or you are involved into any fraudulent action, then also this section is applicable. And to whom this is applicable? This is applicable to the promoters and the first directors and the persons who are subscribed to the memorandum. Then this section 447 will be applicable. When after incorporation, it is proved that company got incorporated by furnishing. What did you furnish? Let us go. You furnish false or incorrect information, any suppressing material fact, like any document or declaration that is this false or any document or declaration is false or incorrect, or suppressing material fact is involved in that, or you are involved in any fraudulent action, or after getting incorporation the company is involved in any fraudulent action, then the promoter plus the first directors and persons in subsection 1. Who are the persons in subsection 1? Clause B. Who are they? All those members who have subscribed to the memorandum. They are liable for section 447. Suppose the above section, number section 6, is proved and you are liable under section 447. Then tribunal comes into the picture and tribunal can take these decisions, right? It can pass order as may be fit for regulation of management of the company, or they can change MOA, AOA. On what basis they are going to change? They change this on the basis of public interest or interest in creditors. Whatever they want, they will do that. Next, they remove the removal of name of company. From where they will remove the name? From ROC. Or it will order us to wind up the company. Any order. It can pass any order as it may deem fit. Suppose you have involved in any of the fraudulent action, or you have provided any false or incorrect information to the ROC during the time of registration, and it is proved after the incorporation of company, then you are liable under section 447. Who are liable? Only the members, promoters, directors, those are liable under section 447. And the company, what does the tribunal do to the company? The tribunal passes the order like changing the management, changing the rules of the company, changing the memorandum of association, changing memorandum of articles. These all changes are brought by the tribunal only in the public interest or interest of the members or interest of the creditors. It can remove the name of the company, it can ask the company to wind up, or anything that can happen. Whatever order it wants, it can pass. But before doing that, it gives an opportunity of being heard and take consideration of the transaction entered into by it. Suppose you have entered into some contracts. So if the company is winding up, it will be difficult to the other party. It may go into losses. So all those things are considered. Opportunity of being heard is given to the company. Whatever they want to say, they can speak in front of the tribunal, and then these decisions are taken by the tribunal. That's all about section 7. Now let's understand what is the word promoter means. Section 2 subsection 69 says about promoters. Let's understand in easy way, guys. I just want to show you in flow charts so that it can be easy for you to understand and remember. So what are promoters? Promoters are those who are named as such in prospectus or identified in annual return. Section 92. Promoters are those persons whose names are written in the prospectus, and these people are identified in the annual return filed by the company, or they has control. It is or, remember this, they has control over affairs of company, whether it can be directly or indirectly. They can control the company directly or indirectly. Directly or indirectly means what way? By as a shareholder they can, as director they can, or anything. Otherwise, whatever it can be. Employee, they can also do it, right? Or advise, show the directions to the company, or any instructions. To whom? They can advise, they can give directions, or they can give instructions to board of directors.